Paglilitis cash advance from Basa Guidotti Enterprises, Inc., Wife's Family Corporation in the amount of 11 million. And likewise, in Exhibit D.
Thank you for that. Excuse me. That was 2003 when the Chief Justice supposedly borrowed 11 million from Basa Enterprises.
That is correct,
Yes,
Your Honor.
just hold there. May we ask from the SEC, during this time, was Basa Enterprises in operation or was it already dissolved? Using your word of the solution of the corporation.
We cannot say whether it's still in operation because they are not submitting reports.
They have not been submitting reports, and therefore you were not familiar whether in 2003, when the cash advance of 11 million was made, was whether the operation was ongoing of Basa Enterprises.
Yes, Your Honor.
Yes, Mr. Prosecutor.
Yeah, thank you,
2003,
Your Honor.
11 million. After which, he declared that there was a decreasing cash advance until it was paid fully in 2010. Is that what you're trying to say?
That is correct, Your Honor.
And so between 2003 and 2010 in the SAL-N, was Basa Enterprises operational? Or you have not received any report again from Basa Enterprises, Mr. SEC?
We did not receive any report.
If there is no report, what does that mean? Oh, that's my time. Answer, please. Both the prosecutor and our witness.
Since the corporation's franchise is already being revoked, and we consider that corporation is dissolved, we no longer ask for the submission of report.
My time is up. I just have one question, Mr. Presiding Officer, only if you allow. I just want to see the point of the prosecutor whether the payment of the cash advance by the Chief Justice to Basa Enterprise has any relevance to the non-disclosure in the SAL-N during that time. It is a corporation of the wife's family, and I want to see the connection. But you can proceed.
For one, if I may just amplify on this point, Your Honors, our theory is that there could not have been any transaction made by Basa Guidotti with the Chief Justice Renato Corona, because the corporation has already been, the corporate franchise has already been dissolved or revoked, and therefore the only action that can be taken by Basa Guidotti is just to liquidate and wind up the affairs of the corporation and distribute the shares. That is all that it could do at that point in time.
When was
if I may just continue.
Counsel,
yes, Your Honor.
when was the revocation issued by the SEC?
April 22, 2003, Your Honor.
2003.
Yes, Your Honor. In addition, yeah.
Your Honor, please.
I'm not through, Your Honor. If I may just continue.
Let the prosecution.
If I may just continue, Your Honor. Also in the SAL-N of Renato Corona, on the dorsal portion of Exhibit C is an entry where Christina R. Corona, with its firm name Basa Guidotti Enterprises, Inc., Wife's Family Corporation, declared nature of business, interest, and or financial connection, which is real estate, and this does not appear, Your Honor, in the SEC records nor in any other records submitted in any government agency, Your Honor. That's why this again is has relevance to the truthfulness and accuracy of the SAL-N, which is also reflected in the SAL-N for 2004, marked as Exhibit E, Exhibit F, Exhibit G, Exhibit H, Exhibit I, Exhibit J, Exhibit K, Exhibit L, all of which are common exhibits, Your Honor.
Anyway,
if Your Honor,
proceed,
if Your Honor,
Counsel.
please.
This will be addressed to the evaluation of the court,
Yes, Your Honor.
especially the effect of revocation. And assuming that the SEC has the power to cancel, to dissolve a corporation, which I doubt, then I do not want to impose my opinion. That's why I'm requesting a memorandum from the SEC. I'm not imposing my opinion on this, although I entertain a grave doubt whether it has the authority to dissolve a corporation, because my knowledge of corporation law suggests to me that only the stockholders can dissolve the corporation by shortening its duration under its articles of incorporation, and or by co-warrant to proceeding by the state if it violates any law. What will be the status of a corporation in dissolution? And after the dissolution, what will be the status of a of the assets of the corporation? My recollection is that in that event, it becomes a matter of co-ownership by the stockholders. So anyway, proceed.
If Your Honor, please, may the defense be heard in connection with this? Since what was presented on record or put into record is a mere manifestation and it has no probative or evidentiary value, may we be heard in connection with this issue, Your Honor?
Correct.
All right, thank you, Your
Proceed.
Honor. May I, in SEC opinion dated May 4, 1995, it is stated the SEC has opined that even under Section 22 of the Corporation Code, there can be no automatic dissolution of a corporation after its incorporation has been approved by the SEC. It shall continue to exist as a juridical entity, notwithstanding its non-operational status, until its certificate of registration is formally revoked by the SEC after due notice and hearing. We had been fed, this Honorable Court had been fed with erroneous presumption, Your Honor, that the moment there is a certificate of revocation, the corporation cannot do any business anymore. That is not true, even in actuality. Supposing that the date of revocation ends up today, and there is a pending case where the corporation is involved, maybe non-payment of wages or recovery of properties, and it's still pending. Would that mean to say that the corporation may no longer participate?
Anyway, that is a question of law that must be resolved.
I'm just reading from the opinion, Your Honor.
If Your Honor, please, may I also be heard on this point?
I'm just reading from the
Let the defense counsel finish first.
Yes, Your Honor.
That is the opinion of the SEC, Your Honor. I'm just reading it for the records because it is very enlightening on the issue involved in this particular instance. Thank you, Your Honor.
Thank you. What's the pleasure of the prosecution?
Yes, Your Honor. First of all, we take exception to the statement that the prosecution is feeding erroneous information to this Honorable Court.
Sorry.
Because 14 years later, Your Honor, in SEC OGC Opinion Number 2409, dated 28 July 2009, the SEC confirmed that the mass revocation orders issued by the SEC are immediately effective. Thus, it ruled. We clarified that an order of revocation is immediately effective. Once the revocation order is issued, a subject corporation's existence is terminated at the very instant. SEC Circular Number 4, Series of 2008, open and close parenthesis, Circular Number 4, for brevity, did not suspend the covered revocation order's immediate effect. It only provides an additional period within which a covered corporation may petition the Commission for lifting the revocation order. The phrase final and executory contained in the circular only means that after the given period, a covered corporation no longer has any further remedy available with the Commission against the respective revocation order. It does not mean that the revocation order is only effective after the lapse of the period for filing the petition to lift. To subscribe to such a view as you submit would render the revocation order inutile and defeat its very purpose. In short,
Anyway,
a covered corporation's existence is deemed terminated until the particular revocation order is lifted.
anyway, the statement read by the prosecution answers the question, how can a dead corporation petition for its revival? So let's leave the matter at that, and that will be taken up by this court in the after we have finished the hearing. All right. Now the SEC is directed by this court to submit a legal memorandum telling this court the basis of its authority to dissolve a corporation without the action of its own stockholders or a co-warrant to proceeding by the state. Thank you. Proceed.
Now, Mr. Witness, after you issued this revocation order, what other action of the Securities and Exchange Commission was made in connection with the revocation of the corporate franchise of Basa Guidotti Enterprises, Inc.?
The Commission issued a circular reminding those covered corporations, those whose certificate of registrations were revoked, to file within a period of 1 year a petition to lift the revocation order.
I am showing you a copy. I am showing you a copy of SEC Circular Number 15, as you testified, dated November 5, 2009, issued by Chairperson Feby Barin, published in Philippine Daily Inquirer November 9, 2009, and Business Mirror November 9, 2009. What is the relation of this document to your earlier statement?
This indicated the date of revocation of the corporation. That is May 26, 2003.
Which document, Your Honor, we have already previously marked as Exhibit 6-D, and the row of the first row of this document from 1936 to 1966, and the date mentioned, which includes the date mentioned May 26, 2003 as the date of revocation, earlier marked as Exhibit 6-D-A. As exhibit D 6-D-A. May I request for a stipulation with the defense counsel on the authenticity of this document by comparing it with the original?
We have no objection, Your Honor, to the issue of